All right, y'all. I'm John Stevens. I'm one of the managing partners at Arena Collective. We have a title company, a law firm, an escrow company, which we might get into now that I think about that and say it out loud. Kyle Berthelot right here. He manages.
How y'all doing?
Yes, this man manages more files than any one of you would want to shake a stick at. Absolute rock star. You can say something about yourself. Sorry.
Yeah, I have great leadership, and it's a pleasure to work for John.
Yeah.
So please give him a round of applause because this is my boss. So
it's on.
This is one of the best. It's one of the best title attorneys in the state right
it's
here.
It's on record. All right, y'all. Look.
I'm the other guy.
Yeah, he's the other one.
I'm the other guy. Right.
That's right. We're going to talk about, we were talking to Cole, what we're going to present on. We've kind of touched on, I think, and maybe it was last year, working with title companies, maybe generally, but we've got a little more zoned in on the wholesaler aspect of that and the approach to what should y'all maybe think about, or what are y'all thinking about in comparison to how we're thinking about it, or what we're thinking about when it comes to processing the deals and making sure the thing gets done as efficiently as possible, with the greatest advantage to all the parties, right? So, without further ado, all right. So this is the template PowerPoint that I started off with. We're talking about pre-ordering, maybe the ideal wholesale structure. I think I got those out of order, so just bear with me. Just kind of the process, right? Every title company has a similar process, obviously, as does pretty much a wholesaler, right? We're all there is some generalized process involved when looking at a deal, underwriting a deal, and then doing the title work, right? Whatever that all looks like. So we've got some pretty general phases or milestones throughout the process here that we'll dive in on. If at any point in time anyone's got questions, by all means, we like to be interactive. Obviously, Kyle brought a thing of alcohol, so if that's any indication of the mingling, we're happy to do that, right? So, but we'll start with a general perspective, right? We're going to dive into each one of these things, and again, don't be a stranger. Ask us questions if you got them, and tell me to move if I need to. All right, so pre-ordering stuff. This is what we're not necessarily the only ones, right? But if you've got a project that you're trying to underwrite, figure out what do the numbers look like, right? Because that's a lot of times where you're starting, is crunching numbers. Part of that's going to be knowing what's on title, right? Because you're going to want to convince the sellers that it's a good deal to them, right? You want it to make sure that it makes sense for everybody involved. One of those things that you want to take note of and consider in that process is you can send us a request. Send me, Kyle, any one of us, right? Hey, look, I got this property. Can you run a pre-screen on it, right? What we'll do is we'll make sure we get a quick abstract done to show any liens of records. We might have judgments in addition to mortgages, right? Or HOA liens, whatever the case might be. We can try to back into what those numbers look like to give you a better picture of what the ceiling on the seller side might look like and therefore what your position might be. All right. We don't charge. I'll say that. If a deal falls through, we're not going to charge you for a pre-screen, right? That's the cost of doing business.
He usually doesn't say that, by the way. That's special for Greg.
But the transmission of information is pivotal in any transaction like this, right? So, obviously, two, making sure and vetting that the seller is telling you as much accurate information as they ought to be, right? And maybe they don't know. You'd be surprised. It's amazing how people, either they're wonderful salespeople or they genuinely are, don't know that they have a judgment against them. And a lot of times it is the fact that they just don't know for whatever reason that might be, or a lien or something like that, right? So whether they're withholding it or whether or not they truly don't know how to articulate all the right information, a pre-screen will help in that respect. There's some screwy stuff, particularly in terms of those partial claims mortgages that came out during COVID. We saw a lot of those. Those can get really tricky when it comes to lenders and your conventional lenders, big outfits. They don't know, the right hand doesn't know what the left hand's doing a lot of times. They'll send payoffs that say this includes all the forbearance modifications or anything like that, and it doesn't. So part of our job is to make sure that obviously we're getting all the numbers straight. Tax title can be an issue, right? We've got tax adjudications or tax sales of record. There are ways to meet a standard of insurability, but you want to get the process started in that as quickly as you can. And that's what one of the things that a pre-screen is going to help out on, okay? Also knowing who must sign. Are you even getting your purchase agreement signed by the correct people? Jared Miguez, everybody. All right. Yeah. Grab that chair. Knowing who's going to sign, right? Because again, you want to get a valid contract. You don't want, if you get a good deal, right, and you've got it locked up, your numbers are right, and you think you've got the one person who's got vesting in the title, the actual owner, then you think you got a good contract. Well, it turns out there's some other people involved, right, and that's not a sufficient contract, and that could open up a whole can of worms. But again, a pre-screen helping in that respect is knowing who's going to be on title. A lot of times we run into deceased individuals. Maybe they haven't opened a succession yet. So is there someone in place who can actually sign on their behalf? And one of the things we can get into, consequences of not having all parties sign a contract, sort of what I mentioned is that, I can't unilaterally sell without proper authority property owned by the three of us, right? Unless they actually give me the authority to do so. If I do try to do that, then your property might get hung up because they're going to sue me, and then there's going to be list pendants involved, and it's going to be a difficult situation to deal with. That's just one example of not having everybody sign, and obviously that's something that you want to shore up on the front end, knowing who's on first.
I can tell you a nightmare situation about that. We had a lady who thought that her husband wrote a will that gave her ownership in the property. She signed a contract, couldn't find the will, and so whenever you can't find the will, your children are going to inherit it. So her son, who she didn't have a relationship with, that lived in Europe, acquired ownership of this property. She didn't have a will, and he had no obligation to sell. Only she did. She would have been breaching contract. So he said, I'm not agreeing to sell unless you give me more than the 50% ownership that he actually had in the property, and she ultimately had to do it. And that could have been avoided by doing a pre-screen, which, for our standpoint, if you need a pre-screen from us, all that means is you send me, Kyle, or John an email with the address of the property. We'll run title, tell you who the owner is, whether it's a person or an entity. We'll let you know if there's any liens on title. We'll get you the legal description so you properly put that in the contracts. You know which lots you're putting and all that type of stuff. And so those pre-screens are very valuable. And people don't take us up on it enough, to be honest with you. I say this every time we give these presentations. If you call us and you ask for 10 pre-screens and send notes, and I see you closing with some other title company 10 times on social media, I'm probably going to say, you got to pay me for them at some point. But if we're closing for you and you every once in a while the closing has to happen somewhere else, or we don't get a file, or you decide not to go through with it, then we don't charge you for that type of stuff. So we want to help you get deals done. We see it as an opportunity that if you go under contract, then the work's already done on our part. We've already looked at the property, we already know who owned it. So it kind of cuts the process down for us once it goes under contract. So don't be nervous or hesitate reaching out thinking you're bothering us, because our goal is to get deals done just like you guys, and unless we can figure out the nuts and bolts of it and get to the bottom of it, then those things don't happen. So
yeah.
Let us know. Who's taking us up on a pre-screen here? Nobody. There we go.
There you go. John has. Yeah. All right.
I'm going in tomorrow.
Yeah. Yes, prove it. All right. All right. What's up?
Tax title. So in Mississippi, Louisiana, it's a lot of times different.
Yeah.
It still has to be confirmed. Still about a 3-month process.
So if it's in Louisiana, I can speak to that, and I think I don't know if Pure Title does Mississippi. Yeah. So they'll run a report. It's like an algorithmic report where they'll give you this package. It costs about $400 or $500. It might not be quite 500, but hey, this is everything that you need to do, right, to meet our insurability standards. Okay. Sometimes the burden is lower, sometimes it's higher. It just depends on what's transpired, right? What can they show? What can they ascertain? It all comes down to due process, right? And so they'll let you know. These people are the ones who haven't received the proper due process notice, right? There are mechanisms built into the law that allow that to happen. or that prescribe the manner in which you do that. I would say, though, you can get that report turned around pretty quickly. Less than a month, easy, right?
Yeah, so 3 months is pretty extended.
Yeah,
It's
yeah.
like
So, you by all means, you can close a tax sale deal or one that has a tax sale issue in the chain of title within 3 months, but it depends on, the main thing is what that report's going to say, right?
Yes.
Sometimes they'll come back to us and say it's insurable
Right.
now.
If somebody has a tax deed and they're, like, they bought a tax deed and they're selling to me.
Well, and have they a confirmed title yet?
Right, no.
Okay.
See,
what I'm
that's
talking
it,
about.
yeah.
So
The confirmed title is the same, I guess.
We would know, we would find that in our pre-screen, when we run the pre-screen, and the confirmation process depends on how long ago that person acquired the tax rights. Statute allows for a shorter procedural requirements if you've held it for a longer period of time, 5 years. So a lot of people say the 3 because that's like the minimum requirement in order for you to bring that suit to quiet title. And does anybody have any idea what tax title is? Anybody wants to clarify that a little bit more? Okay.
Tell me
We're
more.
talking, is
Yeah.
this question tax lien or tax deed? I didn't.
Well, it's effectively the same. A tax sale is going to put a lien on title, yeah.
So what John mentioned was that the issue is the constitutional notice requirement. So there is a group of people in Louisiana that believe that constitutional notice, which is required under the Constitution, constitutional notice, is required whenever the sheriff stands on the courthouse steps and says, Jared didn't pay his property tax, he wants to pay for it, right? And then there's another group of people that believe that that's not whenever notice is required. Notice is required 3 years later once that suit to quiet title is actually filed, when the confirmation suit is filed. And so because there's no real definitive answer to that, most title insurance companies don't want to insure it. They wave their hands and say, we're not touching this because we don't know what the conclusion of any final result of when notice is required. So there's a company out there called U.S. National Title Insurance Company. They believe that post-tax sale notice, that confirmation suit, is sufficient for tax title to be insurable, okay? And so most of the time, in order for you to actually get something through the court system, you have to meet the constitutional requirement, right? That happens when you give a notice of the lawsuit. And so they, like John's saying, they have a company called Pure Title that will run title and cure any defects that come up, but also through Civic Source, that notice requirement, Civic Source will say, okay, if you're gonna file this lawsuit, we know what U.S. National requires from a notice standpoint. And they'll run title through Pure Title, and then Civic Source will blast everybody with notice that's required under the Constitution at that confirmation suit process. And when U.S. National see that Civic Source was involved with it, they've already blessed Civic Source's process to say, we'll insure it on the back end if title actually clears and transfers.
And their title insurance is a little higher than.
Yeah,
So
for sure, there's a,
People, just to be clear, if you want to be really smart about it, remember, somebody asked you a question. The title insurance policy is exactly the same, just like you went through Fidelity and First American. The real difference is that the endorsement that covers the tax sale, and an endorsement is just an addition to coverage, right? So every title policy in and of its, in a box is the same, right? You open the box up, you can add additional coverages in by adding endorsements, right? There's a U.S. National policy on its face does not cover the tax sale. When you add the endorsement in, that's what says it covers the tax sale. And that endorsement starts out at $1,000. And once the purchase price crosses $1,000, it starts going up. And a $200,000 property is usually about a $2,000 endorsement. $300,000 is usually a $3,000 endorsement. So the cost prohibitive part of it is the endorsement you have to add. And just so y'all know, if y'all see that, or you're wholesaling it, or you're a buyer and you own one of these tax titles, if you go to a buyer and you say, I'm gonna cover the tax sale endorsement in your contract, the buyer's gonna then pay the exact same they otherwise would if that tax sale didn't exist. Now, just knowing that when they go to sell it on the back end, that buyer's gonna have to be in the same boat you're at. They gotta negotiate who's gonna pay that tax sale endorsement, and appreciation and everything will require that endorsement to be more expensive. And then the last caveat I'll say to that is that we've spoken to Fidelity, First American, the main underwriters, and this is not like a hard and fast rule, but they say after 10 years of somebody owning a tax title, not just buying it, let me make that clear. After the confirmation suit has happened, if somebody's owned it for a period of 10 years and they possessed it beyond just paying taxes, right?
Open and notorious.
Yeah, they have to hold on to that and build a house on it, rent it out, cut the grass, put a giant billboard that says, I own this property. So if somebody who lost it at tax sale drove by, they'd be like, hold on, that's my property. Somebody got a billboard that says it's theirs on it, right? If you possess it very clearly to the world that you are now possessing this, for 10 years after that confirmation suit, Fidelity and First American will look at it and say, we'll insure, we won't insure it. So it can, and then once that happens, the endorsement doesn't matter anymore, right? And the cost. So if you're a buy and hold investor and you're certain you're going to keep things for a long period of time, it's a little bit safer once you get beyond the tax sale endorsement of acquisition, that when you go to dispose of that property, you may not have that issue on the back.
And there are some instances when if it's adjudicated to the state or the parish or your municipality, the burden is lower in terms of the due process, such that you might not have to do a quiet title lawsuit. Because if you're talking about a quiet title lawsuit, it's going to be more than 3 months, easy, probably 6 at least. Just because of you have to do the arduous due process, right?
And
Service,
what you're doing
et cetera.
is You're reaching out to all the people that may have ownership and saying, hey, we're taking this back. They still have the ability to redeem it during that lawsuit.
Right.
So like in theory, if you really get a hold of somebody and they want it, they have to pay you back the interest plus the taxes you paid. So what you're doing is the course is making sure that before they take something from somebody, that they've been given complete, adequate notice and the ability to take the property back if they want.
He had mentioned earlier, this group of people think this group of people think that, and that's how the appellate courts were for a long time. There was a Supreme Court decision not quite 10 years ago that did say post-sale notice is sufficient for due process, which is how U.S. National is able to rely on that jurisprudence and how they underwrite their files.
Tax title is interesting. And,
Yeah.
It's a fun world to get into if you are okay with all the things that kind of baggage that kind of comes with it, but it's an interesting way to.
Yeah, don't buy it from somebody who has a 1% tax title.
Yeah,
Okay.
That's changing in
Yeah.
January, right? All that percentage of liens.
I don't know.
Yeah, it's interesting.
Yeah.
And we've had people who have bought that 1% interest and then they will then partition the property because they own 1% and the owners own the rest of it, and they force the sale,
Right.
partition.
Yeah.
Where did you hear that with the 1%
At a
change?
tax lien workshop
Okay.
I went to in Baton Rouge.
Nice. Very
Who
good.
was
Yeah, was it
who
Fidelity or?
Ben, you quit from Indiana, but he said that January 1st, 2026, Louisiana has a law that's going to
Nice.
change the percentage thing on tax liens.
Cool.
Yeah. Interesting.
We'll report back.
Oh, yeah.
Yeah.
it's-
Very good.
They gave you
Emily,
homework.
You
It's
need a
good.
job? Here we go. All right. Idea wholesale structure, right? So obviously we do a lot of that in here. We're creative people, and we want to figure out the creative way that works the best in any given situation, because there is no exactly correct answer. These are the ones I came up with to talk about. Obviously, we know assignments. We know double closes. Typically, that's going to utilize pass-through funding. Maybe a short-term seller finance to holding pattern type thing to hold it while you find who you want, just to make that seller feel better about something actually happening. Maybe they're getting some money. And then the novation approach. And I put that in quotes because people bastardize that legal terminology a lot, but we'll get into that. All right, assignment deals. How many of y'all have done an assignment deal before? All right, yeah, we know how that works, right? All right, so Louisiana law, our rights may be assigned, right? With the exception, don't worry about that second sentence. That's not going to involve us. The assignee, the person you're assigning it to, is subrogated to the rights of the assignor against the debtor. Just think of that in terms of they're going to fill your shoes, right? However, a right cannot be assigned when the contract from which it arises prohibits an assignment, right? So if a contract is silent, right? If your purchase agreement does not say this contract cannot be assigned, then it can be assigned, all right? So it's a presumed right, not presumed not a right. So that means if you're looking at a deal and someone's savvy enough to try to tell you to put that in there, you don't have to put that in there, right? Or you might not want to put that in there.
And the Louisiana buy-sell agreement that most real estate agents use does not prohibit assignability, so by default, that is assignable.
Yeah. And so we know how this works, right? You're going to get under contract on an AB contract. You're going to look for somebody to assign it to in a BC contract. All right, this is a single close. This would be a single close type of, we'll see the double close here in a minute, but a single close assignment deal. You're typically going to want to give yourself a pretty good inspection period there, right? Like until closing. We definitely see that. That just gives you the right to back out if you need to back out. If you can't find that buyer that you want to buy or buy from you or replace your position in the contract. One thing to remember, an assignment does not in and of itself release the original buyer. So right, on your AB, you're not released unless something in your AB contract says that you are, right? And you have some additional paperwork, and we'll see that a little bit more under the novation stuff, but just keep that in mind, right? You're still bound under your contract, and so you're gonna want to just keep that in mind. Now, you could be creative and get into some of the stuff that we see in a little bit, but this happens a lot. It works a lot, right? If it's the deal that's a good assignment deal, you're not looking to long term hold that and just kind of make some flip money. You can do it well with those. I did find this an interesting code article. The assigner of a right must deliver the assignee all documents in his possession that evidence the right. How many people do that? Yeah, nobody does that. Nobody does that.
Disclosures and,
Yeah.
And all the contracts and all that as part of that transfer from the assignment of right.
And look, I mean, this is kind of honestly, this is news to me. I mean, like, because it just doesn't, doesn't have. Nevertheless, a failure to do so does not affect the validity of the assignment. Very good, very good.
It does really matter.
We have some friends in the legislature.
Yeah.
All right.
So and who does not understand assignment deals? Who, you know, want me to, or us to explain that any further? Everybody understands that is pretty well? Okay, cool.
For example, yep, if I got a house, I want to get out of it. Jared says I'm going to buy it from you, and then he says he's going to, or he doesn't say, he may or may not say he's going to go find Kyle to buy his position.
That's the blessing of the assignment. He doesn't need the original seller to redo it. Right.
That's right. Right. Hence the hook, right? Hence the hook to Jared, right? And still being obligated under my contract. All right.
Yeah.
So how does that work as a realtor?
As a
Might
wholesaler?
wanna do that.
Yeah.
Right.
As a realtor?
Yeah.
I wouldn't decide.
It's a hard
Yeah.
deal to thread. We've had a couple of real estate agents that were wholesalers, and the LREC won't really give a clear answer on what they want you to do and how they want you to handle it. The guy in front of you probably knows better than I do.
Well, look, and we'll see some, because there's some examples of that kind of innovation stuff too.
If you think about it, the nature of a real estate agent, whenever you meet with somebody, you want to get the highest price for it. But the nature of a wholesaler is you want to get it under contract for the lowest price so that you can turn around and sell it to the buyer for the highest price. So you're playing on both sides.
Yeah.
It's hard.
Yeah.
And they want you to, the LREC wants you to walk in as a realtor and try your best to be a real estate agent if you have a license first. And then if that deal doesn't work, then you can present yourself and clearly state that this is not me acting as a realtor. I'm here acting as an investor for myself, my own purposes to do this. But it's still a difficult thing to do. John also may have some.
Yeah, I was just gonna say, it depends on how you're approaching it. If you're going in as a listing agent, you want to potentially work with, you have an obligation of confidentiality. Anything they share with you, you use it then to negotiate against them. You're potentially putting yourself in hot water ethically. If you walk in the door as an investor and disclose, look, I'm not representing you, anything you tell me, I'm gonna use to my advantage.
Get that in writing.
That's different.
Right.
Yeah.
Your contract should definitely
Yeah.
state that you're an agent, but you're not their agent, you're not
What's up, John?
John, what you got, buddy?
My purchase agreement's separate from because I'm a licensed agent. All of my emails for the wholesaling company that I work for have a disclosure disclaimer, and then when I do things, I have a separate acquisition company that I run that it's in my contracts, it's in my email signatures, it's on the website.
Yeah.
Anywhere they can go to find that, explicitly says I'm a licensed realtor in the state of Louisiana, and then the contracts explicitly say that I'm not, there's no agency representation on buyer or seller.
Yeah.
In the transaction.
Yeah. It's a thin line to walk sometimes. I mean, same thing.
I've heard other things too. I've heard that you can't pretend that you can't be both.
I mean,
This day, I'm gonna wear this jacket.
there's certainly nothing that says you can, right? I mean, just likewise that there's nothing. What it's going to take is a lawsuit, right, and see what legislation happens. I mean, that's what we have to deal with every day. It's like, hey, what's the answer to this? Well, it depends, right? Depends on what somebody says. Depends on what argument might arise and what the facts are, surrounding that. So.
And if you're in New Orleans, you're going to lose because it's impossible to argue in New Orleans. So it depends on which
Yeah.
jurisdiction you're in.
Yeah, it's not easy. Okay. Moving along, the double close. All right, so typically, for those of us who don't have just a ton of liquid cash laying around, right, it's a pass-through funding mechanism, all right? So as opposed to the single close assignment deal, all right, which again is I'm the seller, I'm under contract with Jared, Jared assigns it to Kyle, I go to closing and I assign a deed to Kyle, right? That's your single close assignment.
And Kyle's money goes straight to John. It doesn't pass through a transaction that I own.
Yeah.
Kyle, I get a fee for selling to Kyle at closing, but Kyle's money goes straight to John.
Yeah, yeah, exactly. So double close is going to be a situation where, all right, I'm under contract with Jared. Jared signs a separate purchase agreement with Kyle. That's not an assignment of my contract, right? So if I'm selling to Jared for 100, he sells it to Kyle for 125. Typically what's going to happen is that Kyle's going to come buy it from Jared first. Jared's money in escrow is going to be used to fund my deal, okay? And so Jared's spread comes from that double close situation as opposed to the single close assignment fee on the single transaction.
Effectively a flip on the same day.
Yeah, yeah. Does that make sense? Anyone got questions on that?
Yeah,
Right?
double the fees, double the title costs?
Not necessarily. We, so I mean,
We charging twice the fee?
yeah.
I was about to say, we just had this conversation
Yeah.
a while ago.
Just had it. No.
For the right person, I mean, we
Yeah.
usually take care of our
Yeah,
take
yeah.
care of our people, right?
No. I mean,
You don't get title on
there's
the first.
hardly any.
Right.
I don't know that anyone's ever.
He's giving us softballs here.
Yeah.
Yeah, on the BC transaction, or the AB transaction, me as the wholesaler, I'm not gonna get a title insurance policy, so that cost is gone. We generally speaking don't charge the person who's buying and then selling on the same day a full fee. We do have to open a file. We have a little bit of a fee that we tack on to that AB and that BC transaction. But most of the typical fee that can be paid by the owner that's selling to the wholesaler, and then the buyer who's gonna pay for their title insurance and all those same things.
What about
Yeah.
sales tax?
No sales tax in Louisiana.
You talking about dock tax
Yeah.
in Orleans?
So it'll be in Orleans, a transfer tax.
Yeah.
Yeah,
In Orleans, yeah.
Right.
Yeah. There's going to be dock tax.
The wholesalers on the BC deal would have to pay the dock tax fee. Now, the
Yeah.
recording fees have to be paid on both transactions because we are recording two deeds on the same day and all that. So the wholesaler is going to end up paying those recording fees whenever they buy it, and then when they sell it, the end buyer is going to pay the recording fees on the end transaction. And that's all assuming that the parties don't negotiate a different fee, which some of our main wholesalers will charge. They'll say that the end buyer is going to pay all the fees, the seller is going to pay all the fee, and they usually end up not paying anything in the middle. We did a deal the other day where a wholesaler made like $25,000, and they still negotiated that the parties paid the fee on the BC deal, which is like,
Yeah.
it's pretty.
Is that Brett?
Yeah.
pretty
Maybe
impressive,
no. But in New Orleans, though, yeah, that's where you've got dock tax fees.
I had a call today from an investor that said that he's flipping an $800,000 property under contract. He's going to sell it for 1.2, and he doesn't need pass-through funding. He's going to fund the.
Oh yeah, see, yeah.
Yeah.
That's where is he? Come on,
Right.
yeah.
So what would be the advantage of a wholesaler going double close instead of an assignment? Is it just to hide the fee?
I was about to say anonymity for one.
Well, keeping
right?
people separate. I mean,
Right.
we still keep buyers and sellers separate even on assignment. We do blind HUDs, but still, some people just don't want to risk them being in the same room or seeing the transfer. And sometimes, I mean, I don't know if John touched on this, but it's important to us that we work with wholesalers that do everything above board and are honest and open to people. And if some wholesalers don't tell the seller that they're flipping it, and they don't want anybody to know, and so they keep it totally separate with two transactions so that the seller thinks that they're the buyer. Sometimes it doesn't make me feel super comfortable about the deal, but sometimes they do that because they feel like nobody's going to know. Now, if somebody knows how to go to the record, they can clearly see that the flip happened on the same day. But most people that are selling property don't know how to do that or care much after the transaction's closed.
I will say at one point, this was probably like 4 or 5 years ago, there was a lot more. It seemed like a lot more double closes than mostly now. I feel like by and large it's an assignment deal when it comes through. But
Is that because of the change in HUD statement where you're not showing both sides like you used to do?
I like
No.
to think that we were the pioneer in
Yeah.
using those blind
the
Yeah.
one side.
I mean, look, I think some of the times there's pressure. Like you get a couple title companies that are in the market that are open to being creative and doing these things, and everybody
Right.
kind of has to step up. When like maybe 10 years ago, whenever wholesaling was like taboo, people were like, we don't touch those things. Like I mean, it's completely legal and contractual. Again, as long as everybody's on the up and up and nobody's trying to pull the wool over anybody's eyes and being honest, you know, creative real estate is what people do in these type of markets, like to get the deals done. So I think that there's been other title companies and us that are open to these types of things and requires people to be open, other people to be open, or they're going to lose out on people who are willing to do things.
And the assignment contracts have gotten better. Like they're more effective now. Whereas before it was kind of like, we haven't really done this a lot. Let's just do a double close, easy peasy. Now that
Yeah.
everybody's so good at it, and it's well
Yeah.
kind of articulated that it's it's the same thing. We can just
Essentially, you're just partnering with the wholesaler who's taking on all the marketing costs for acquiring the
Yeah.
property. So
Yeah.
that's the language that you should use as a wholesaler is, my partner, if they see two deeds, they're, look, my partner's
Yeah.
taking over this one,
Yep. No, I mean, and a lot of times that's the truth. I mean, of the matter, the seller might not be able to sell it if it weren't for that happening, right?
Mhm.
So, and if they're in a situation where they need to, by all means. But okay, here we go. The sale of a thing belonging to another does not convey ownership. That's why we, make sure to record things in a certain order to where the chain of title is fluid, and not that there are instances where it wouldn't be considered still valid, but if I sell a deed, if I execute a cash deed to Kyle of a property that I'm closing on with John next week, he doesn't have title for a week, right? He doesn't own that thing for a week, not until I get that deed from John, and that's the after acquired title doctrine. So that just because they're out of order doesn't mean it's not legitimate, right? You can plug in gaps in the chain of title with instruments that convey ownership.
Is everybody?
So we just make sure I understand, I'm trying to say that, so if I have a deal, Brett's selling me a house, and I'm selling it to him, but I'm gonna close with him before I actually get the title to Brett, but I'm just gonna tell him he's not gonna get his title till a week after I close with Brett?
Hopefully you don't wait a week to close them, right?
Yeah, we try to make it a
Typically you
little
do
tighter than
back
that,
to back. But yes,
fair market.
That's
but yes,
what it is.
but yes.
I'm closing with him, I'm closing with Brett before I'm actually closing with him, but he's not getting the title.
Right.
I'm closing with him first.
Right.
But he's not getting the title.
Yeah, because you haven't actually conveyed ownership, right? Because you haven't gotten it yet.
Little thing belonging to another.
Yeah. Now but again, right? There's always caveats. A future thing may be the object of a contract of sale, so you can do that, right? You can contract based on a future thing of which you might come into ownership at a later date. That's not an invalid act under the law. Okay. Now, if you screw it up, right, and you breach a contract, then again, that's the can of worms that we always talk to. But
So it's almost like this property is up for grabs, but then you negotiate to a buyer that you have that potentially might be interested in this property. You negotiate a sell price to him, kind of get that deal squared away before going and talking to the seller and getting that deal squared away?
Most often it's in the opposite order of that, right? Most often you're going to lock it in with your seller first, and then that wouldn't be invalid. Okay, it can be the object of a contract, but most often you're going to shore up what your starting point is before. Yeah, right. But
We do it like an option to buy a property with the caveat of putting that property under contract.
yeah,
The guy today that I talked to, he has an end buyer that has agreed to pay a price. It's not even contracted yet, but he knows that person is going to agree to buy it, and he is now negotiating with the owners, because there's several owners, so he's trying to get everybody on board. He knows he has an end buyer, and if you talk to a lot of the wholesalers in this room, John Lester does this really well. He has several buyers that he has on the hook that he knows what they want. So he pretty much knows that he finds that property, they're going to buy it for this price. That's what they've talked about. So it's his job now to go find those properties, get them for the best price, to be able to turn around and sell to those people. Right, John? Yep. So he hasn't actually signed paper selling it to them yet, but they all have the terms already ironed out.
yeah,
Right.
yeah,
That might be interested.
exactly. And yep.
Quick question. Did I understand that whenever you're going from A, B, C, that if I'm the B person with the A person, that
So what,
Is that what I understood?
I think he was saying that option to purchase from the end buyer, correct, John? Yeah, so he would say, hey, let's say you've got a really good conversation going with an owner of a property, you're close, and John wants to buy it, right? He's been talking to you, hey, this was perfect for him. You can sign an option with him and say, hey, if you get that under contract, I agree to buy it from you for XYZ, okay? The suspensive condition in that contract is him getting a contract to purchase it from the actual seller, right? So the option will then be available to him upon you getting the contract with the seller, okay? And so if he exercises that option, he's locked in to buy it from you, right? So on the ABC, going back to kind of clear that up just a little bit though, again, I think, correct me if I'm wrong, most often it would be, hey, Kyle's got a piece of property for sale, okay? I go negotiate with Kyle, all right, buddy, I've worked him down to 75. All right, I've got a purchase agreement with him. He's selling it to me for $75,000. And if I know John wants to buy, he's been telling me he wants to buy that property and he's like, I'm willing to put 100 on it, right? Then I can then execute a contract, an assignment contract to him, assigning my rights and my purchase agreement to him. He has to perform according to this, right? He's got to do whatever I agree to do in this contract with Kyle. And then he's paying $25,000 more. So then Kyle's going to sell it to him in a single close assignment. I'm going to make $25,000, right? That's the general framework of that. Does that make sense?
Yeah.
Cool.
That's
Yeah,
on the assignment,
because
on the
that's
double
on the
close,
assignment
right?
deal.
Yeah.
Yeah, that's on the assignment deal. On a double close, it could work similarly, right? I'm under contract with him for 75, and then I execute an entirely new purchase agreement to John saying you're going to buy it from me for 100. And we did 2 closings where first he's going to give me $100,000. I'm going to take 75 of that and give it to him in a separate closing.
But all on the same day. for the-
We try.
What's that?
That's the idea.
The title exchange. So he's going to convey title to me, or excuse me, I'm going to convey it to him. He's going to convey it to me. We're going to record our deed, and then we're going to record our deed, right?
So what happens if you have an agreement with Kyle that you're gonna buy his property, but you're depending on John to fund it, and John backs out?
Yeah, the
Then
liability.
I'm on the hook.
liability
I'm on the
aspect,
hook.
Right.
That's
right.
why we tell you have the due diligence period for
As
this
long-
AB deal throughout the entire contract
Sure.
period in case they.
If he backs out,
Raise your hand if your name's John in this room.
yeah,
There's a lot of Johns here. We can refer to
good
them as
guys.
John.
Yes.
What's a good clause to use in the contract to get off the hook?
Give yourself
Time.
an inspection period that you can unilaterally back out without any consequence and get your deposit back up to the date of closing.
Right.
I thought you were saying your name was John Murray.
Yeah, me too. I was like, I'm hanging out with this lady.
So with that inspection clause, I can just say, yeah, I can just give a BS reason why I want to back out.
Well, I mean, if you give yourself a unilateral, if you give yourself the authority to back out for any reason in your sole discretion, and look, that happens under contracts outside of real estate for sure. And
It
so,
almost has a financing clause in there too. and
Yeah.
Say that your financing fell through because John fell through.
Okay.
yeah. Now look, that's on your assignment deal.
So technically, if John's buying it from you, you're gonna close with him, and then you're gonna go close with the original seller.
Correct. I'm
Right.
using his money.
But who's on title,
So all right, so the day of closing, it starts with Kyle being on title, and then it ends with John being on title, right? Only because we just happen to schedule, hey, it works out for him, right? And this isn't, I mean, it's not like there's anything, just think about it this way. He can only show up at 10 o'clock, right, in the morning, all right? I'll show up at 10 o'clock and sign my paperwork. That's a dry closing, right, effectively. We'll have the money in escrow, but it's dry in terms of he's not the owner yet. And then at 10:30, when it works out for Kyle, I go in here, he sells it to me, right? And therefore, the chain of title goes from Kyle to me to John. And I didn't have to use my money, right, to give to Kyle first and then wait to get John's money. All right, so, and that's okay under the law, even if you waited a day.
Right,
Let's
even
say
if you did swap,
if
right.
someone were willing to wait the next day, right? If a buyer said, hey, if John said, I got to close on Thursday, Kyle can't do it until Friday, and John was okay with that, let's say we close his deal, and even if we record his deed and we close my deal the next day, and record my deed thereafter, that's fine. It's the after acquired title doctrine in Louisiana that says if you fill in the gap with a later executed act to complete the chain of title, then the chain of title is complete.
But technically,
But we wouldn't.
Isn't a dry closing illegal in the state of Louisiana? Technically?
Not that, I mean,
No, not at
no.
all. A lender might not.
Oh, a lender, yeah. You're not going to get it with a
Sure.
lender. Yeah,
Probably about.
that's an underwriting issue.
What do you think, Chris?
What?
What do you think? Lender's gonna.
Space that for a second.
Yeah.
And
No.
Steven in the back, both of them lenders, they'd be able to tell you that.
Most lenders,
He's a lender
most
too.
lenders
Yeah.
aren't down with double closes.
And look, I mean, so think about it in this context, because this is something I've been researching lately because we've been launching our escrow company and we've done it in the past, and it's not uncommon. Let's say on a bond for deed, right? I go on a bond for deed with you. I'm going to pay you $100,000 for this property over 12 months, okay? When I fully pay you and I fully perform, you execute a cash deed in my favor, right? And then I become the owner. Well, let's just say you're moving to Hawaii, all right? The day we sign the bond for deed, we also sign a cash deed. That's held in escrow, right? So again, it doesn't convey ownership. It's not legally effective until I complete and fulfill the suspensive conditions, right, of performing fully under the bond for deed. So it's a similar concept, right? This deed's executed, but it's not given its legal effect until whatever condition is required to give it its legal effect occurs.
It's an open-ended transaction, bond for deed until it's actually closed.
That's right, right. And you're not being an owner until you pay it all off.
Good job, John.
So,
In the situation where you have, you sign closing documents between B and C, and then an hour later, seller A comes in, sits down, says, you know what, I changed my mind, walk out the door. You've got the money in escrow,
Money goes back to John,
unwind
Right.
everything.
and people get to sue people, yeah,
Yeah.
if they want to, right?
We've been-
You ask your title company to make sure the deal happens, and we sit down and we have a conversation
Yeah.
with the seller and make it work. However,
The
it's
title company should
whatever
ex-
it's needed.
Yeah, pro se
to do to
verbal.
get it. Right.
That's why you have title company. You're gonna hold the money.
Right.
Until everything
Precisely.
is done.
Right.
Precisely.
So when somebody shows their behind and walks out the door,
Yeah,
nobody else is hurt.
Yeah.
The money's just returned. It's like, none of us trust the other people in doing business, unless we've done business with them, we know them, but we trust title companies.
yeah,
You're gonna hold the money in good faith, it's not going anywhere but where it
Right.
belongs.
yeah.
I'll say this, I've seen a lot of investors write contracts, and there's no breach of contract provisions in the contract. None. There's no consequences for the buyer or the seller not showing up. Makes no sense to me. You know, the Louisiana buy-sell agreement has a pretty steep penalty for not showing up. 10% of the purchase price can be sued for damages, but I've seen zero default provisions in those contracts. It holds people accountable to nothing.
And we know you want your contracts to be as short and succinct as possible because you don't want to overwhelm anybody when you're working with them, right? That's understandable. But you do have to put your protections in place. I mean, look, we've held something off for a couple of days because a lady who was the buyer in a bond for deed came in to do the closing where she got the deed, and she was like, I didn't know how to bring you money, and she won't give him money. So it's like, well, you don't own the property. You know, I mean, we don't know what to tell you. So it's dry right now. It's half wet, half dry. The seller put some money up.
Could you not just put a clause behind the earnest money saying that you accept this full liquid for any breach?
Yeah, I'll
So-
say, let's talk about that term, earnest money.
Earnest money versus deposit, right?
So, a lot of people will even, and John Silver knows this, a lot of real estate agents will refer to the deposit as earnest money. If you pull the definition of earnest money, it is.
In Louisiana, at
In
least.
Louisiana, that is stipulated damages for a contract. So technically, if you have earnest money in the contract, all the other damage provisions in there don't apply. Earnest money is seen as the stipulated damages that in the case somebody backs out, the other party gets that deposit, that earnest money, and that's it. There's no other damage provisions in there, or that apply. So if you're gonna refer to it as earnest money deposit, you need to make sure that you anticipate that being the only remedy for default. Now, if you're writing your own contracts and you wanna give some sort of teeth to the deal, but you don't wanna write some elaborate damage provision, then yeah, call it earnest money, which case has the buyer on the hook for losing their deposit, but don't make the deposit $100. You
Yeah.
know? Like, that's a get out of jail free card. Make it have some teeth to it, $1,000, $2,000, 10%, 1% of the price.
You can call it a deposit. Don't
Yeah.
call it an earnest. money deposit.
If you want that to be it. Now, if you're gonna write into the contract
Right.
that you pay a deposit, if you breach, you lose your deposit, plus 10% damages, don't call it earnest money, because when you say earnest money, you're assuming that that other 10% doesn't apply. Earnest money, when you call it earnest money, that is seen as the sole amount of damages that are gonna be traded between the parties in the case somebody's in default.
So earnest money is a different legal definition.
Yep.
Then
Yeah.
And people
In
use that term
Louisiana,
interchangeably, and
well,
they don't
in
know.
Louisiana common law, I'm pretty sure it doesn't have the same effect.
In Louisiana,
Yeah,
earnest money
of course.
is the total amount of damages that is anticipated whenever you call it earnest money. So EMD, earnest money deposit, is technically not the correct term if you're using a Louisiana buy-sell agreement based on the provisions in that contract.
Now, if anyone wants to start a Qualia type company in Louisiana
Yeah.
that doesn't use that nomenclature in their software,
Yeah, that'd be great.
let us know.
So, and I'll say that to round that conversation out, if you need help writing your damage provisions, let us know. We can give you some language that y'all can plug into your contract that will help y'all in the case that you're a wholesaler and you want, in your assignment contract or in your double close contracts, for your end buyer to be on the hook for some sort of consequence if they don't show up, and you end up having to turn around and maybe buy that property, or
Yeah.
if you have damages for the
Which
property.
look, we deal with good people. I mean, look, Brett and them, you know, they've been in a situation before. They say, well, we're not going to string this person along, right? We're going to do what's right. We know we're on the hook, so we're going to make it happen, and we'll figure it out from
find a
there,
way.
right? So you also kind of got to consider in the back of your head, if that actually does happen, right? What does it mean, just from a legal contractual standpoint, and what your exposure might be, but also maybe from a goodwill standpoint with respect to your business, and you know, making sure that you're doing right by people. So happy to help. Happy to help. All right, seller finance considerations. This one kind of came on a whim, but maybe it makes sense. Hey, this person, the seller, has just really got to get something in place, and like they want to be out of here. Something, maybe the contract, the purchase agreement in and of itself isn't enough for them. You might consider doing a short-term seller finance where, hey, yeah, I'll buy it from X amount, and then for whatever payment you can negotiate. Maybe a shorter balloon period makes them happy, whatever the case might be. You negotiate that as you want to, but using that as kind of a stopgap to buy you some time to find another end buyer, right? And so that's just throwing that out there. And we'll talk about some seller finance stuff with bond for deeds and credit sales here in a minute. But just in terms of, again, what can you have in your creativity toolbox that will get your deal at least kind of locked in as best you can, so that you can go do your job.
Outside of
and do
just
what you're
throwing
good at.
money at them, which is what a lot of people
Right.
just start giving them money on the table. Let's do it legit. Let's do
Right.
some kind of creative
Yeah,
seller
right,
finance.
I'll pay your
We can
mortgage.
do it
Which
quickly.
that's fine too. Look, we've had people say, look, I'll
Right.
pay your mortgage statements, for the next 2 months while I work on this, but you might want something a little better than that, protecting yourself too, and your rights to that property. That's a good point though. All right, novation approach. Any questions on the seller finance stuff, real quick? Nope, good. All right.
I'm gonna go to the restroom during novation.
Yeah.
Well, it's because go ahead. He's not.
All right. How many? Raise your hand if you've done a novation deal. Brett thinks he has. No,
Yeah.
he's kidding. That's pretty close. Yeah. All right. So a novation is a contract. So we'll go back to the example. I'm buying from Kyle, right? I'm obligated party to purchase from him. He's obligated to sell to me. Me assigning it to John is not a novation, right? I don't think that is a common misconception. I am effectively replacing in a single close assignment deal the buyer, right? But I'm not extinguishing my obligation under the original contract, right? So a novation is going to occur when Kyle completely understands, right, that I'm no longer in the picture, whatever that looks like, and he's going to execute a contract with John directly, all right? So me as a subject to that contract, a subjective novation, that's what that is. I'm out, all right? An objective novation is if me and Kyle are in a contract to buy 123 Main Street, he's selling that to me, and then we go into contract, instead I want, 234, right? Main Street. We're replacing the object of the contract. So again, the intention to extinguish the original obligation must be clear. A novation takes place when the agreement of the parties, a new performance is substituted, or a new cause, right? So if the biggest part is if any substantial part of the original performance is still owed, there's no novation, right? So again, an assignment, there's no novation there because I'm still obligated to purchase from Kyle. So again, remember, novation completely replaces and extinguishes the original contract. So kind of an example of where it actually constitutes a novation, and again, look, we don't care what word you call it, right? There's plenty of ways to dress up a deal and make them work, so they could be very similar to this, even though they're not an actual novation under the law. It doesn't matter. It doesn't mean it's not valid. All right, let's say I go into contract to buy from Kyle again. All right, so but in our AB contract, it says that hey, once I find a new buyer, we're going to replace it. Obviously, right? We're being expressed in terms of replacing me as a buyer with this person as a buyer. You're obviously, or most often, you're going to put in their terms and conditions, which I'll get into a second, which say, what are you going to be compensated for that, right? Because if you just completely replace your contract with somebody else, unless you've got a contract with that somebody else that says you're going to pay me the X amount of dollars for whatever reason, you're not getting anything out of the deal, right? So what we typically see is in that original contract is going to include the authority for me as the buyer. I'm buying from Kyle to market. If I'm an agent, put it on the MLS, right? List the property. That kind of gets back into some of this gray area that we talked about earlier. But it could still happen as long as depending on the nature of some of the more nuanced terms and conditions. So, which I'll get to in a sec. But to market, list the property, conduct renovations, right? Deal with permitting. We typically will encourage or draft a power of attorney to go with it, right? In some instances, if you say, hey, I'm going to go on a contract from you. Here's what I'm going to do though. In addition to me saying I'm going to buy it from you for $100,000, I'm going to renovate it, okay? And then I'm going to get whatever is in excess of $100,000 once I go list it and get a new person under contract. All right, so sometimes in addition to a power of attorney, we'll put a note and a multiple indebtedness mortgage in there to make sure that you're protected for the costs and everything you put into the property. But again, the power of attorney is big with respect to you being able to actually do these things and have the legal authority to do so if anyone were to ask, okay? But often kind of what we see more of maybe is a transaction where we get a combination of an assignment deal mixed with some common joint venture provisions, which are, a lot of times a joint venture might be that me and Kyle are going to buy this piece of property. I'm going to do all this work. I'm going to do the construction or calls for the construction to be done. You're going to get this amount or this percentage whenever we sell it. I'm going to get this percentage whenever we sell it after getting my costs of labor and materials back. But it might not be an actual novation because if I'm buying, or let's say, if I'm buying from Kyle in that respect, right, and then I just assign my contract to somebody else after I do all the work, right? So again, I'm not extinguishing my obligation to purchase, but a lot of times they are set up that way, particularly when you got people who are savvy with marketing and listing the property and being able to use those avenues to do a good job of marking up what you're getting. Right, and as long as you're not just like completely saddlebagging, I think your seller. I mean, if you go in and say, "Hey, look, we're gonna work on this together. I'm gonna make sure I get my materials and costs back. Right? Here's a base level purchase price that I'm gonna give you, and then on top of that, I'll give you X percentage of whatever's in excess. Right after I get what's owed to me." And so that's where you can kind of get really creative. So if you've got the hat of a real estate agent on or contractor's license, or if you know people in that sphere who can help you kind of grease the wheel on these deals, that can be very effective. Sometimes they go a little longer, particularly if there's renovations involved, but you can turn the numbers up pretty good on them with a good ARV involved. Does that make sense? I know that's a lot. Who's got questions on that? Cool. And you might just do it as a straight up joint venture. I mean, like you were saying earlier, it's kind of like a partnership, right, in a way, and that's a lot of what a joint venture looks like. Cool. Good on this?
About 10 minutes left.
Okay. Oh yeah. Okay. Here we go. Let's blast it. All right. New order. Jared, you do this part.
I don't know.
Kyle, you do this
I
part.
haven't seen the slides yet, but
You made it.
I did, okay.
Yeah.
That's the info. Is that what we're going
No,
through,
no,
like-
that's just, hey, now, look, all right, so this is basically, all right, new order. This just goes into, all right, what happens whenever you're sending it to us. New order etiquette, find out who at the title company manages the intake, best you can, right? We've got a centralized person who does that.
I'll say, to a little point to that, we have a couple of really strong wholesalers do a lot of volume. And generally speaking, if you have a wholesale deal that's really working and the person's in a distressed situation, they're usually not communicative. They're harder to get in touch with. We actually have an intake link that we'll give to our wholesalers, and they've already built a rapport with these people. They will actually connect our intake and information with that person and get the information for us to speed the process up. Everybody's going to send us a 10-day turnaround on a wholesale deal, and we're never going to get the seller on the phone. If you do enough volume, we'll give you our intake link, and then you can say, hey, title company needs this if we're going to close this deal quickly, and they'll help us get that information. So if you know that your seller is in that type of situation or they're that type of person, and we're going to let you know within a relatively short amount of time we can't get the information, but we'll send you our intake link. Y'all can get that to them, help them fill it out, so we can get the information quicker and get the ball rolling.
Yeah, and that's huge. I mean, we'll have that situation. And furthermore, to that point, I mean, there are some people who we work with, and I might regret, don't let me regret saying this, but I mean, like we can schedule regular meetings to go over your files with us, right? And there are a lot of times, whether it's a wholesaler who's got 1 or 2 at a time versus someone who's got 12, you know, with that intake, hey, look, we've called this person 5 times, we've emailed them, we're not getting anything. They will literally, in 5 minutes, they'll have them on the phone, right? Okay, send a link to them, get the information that they need. Because again, you've got the relationship with them.
Yeah, that weekly call for those wholesalers who do a lot of volume allows us, because they're very creative. So it allows us to understand what they're thinking, how they're structuring the deal in real time, as opposed to us getting some contracts and not being able to really read between the lines very well. And so after we've done a couple of deals with somebody, we know that we would tend to do better with a weekly meeting. If you have enough volume, we'll set aside 15, 20 minutes a week on a consistent basis for us to connect and make sure we're all on the same page.
Yeah. When to send in a wholesale deal? That's a good look. That's actually a really good question, right? Obviously, if you get under contract, we talked about pre-screens earlier. Send us a pre-screen. That doesn't mean that you're sending us the contract and we're going to start, you know, calling that person to get their information from them, right? That's us just doing some due diligence on the front end.
And practically speaking, we have a whole system that allows us to open files that are called pre-orders, and we save all those abstracts in the file. So, I mean, if we do that pre-screen and it doesn't work out the first round and you have a couple of other people that are looking at it, like, again, that we're not just doing that and sending an email and forgetting about it. It's in our system. We search that and we can pull that out and allows us to go faster.
Yeah.
So it is helpful.
Well, probably one of the bigger things is the borrower authorizations, right? Payoff authorizations. If you can get that, as soon as you can get that executed, that just says, hey, this person or these people have the ability to, you know, communicate with my mortgage company or whomever as any liens affecting the property, right? We can help give you a blanket form for that. That is hugely helpful.
Who gets those signed on the very front end of the deal?
We don't see many people do.
If you're a real estate agent and you're a listing agent, it's helpful, again, if your client's not communicative, but even if you're a wholesaler, that saves us so much time, because inevitably when we get the contract, even if we can't get in touch with somebody, if we run title on it, we find out that there's a lien, that's usually part of the process that takes longer. And so if we have to also go through the step of getting them to sign an authorization before we go speak to the creditor to get the payoff, it's gonna add days.
Yeah.
Sometimes weeks. So if y'all have that on the front end, like I said, we'll give you a form that allows, it's a blank for the wholesaler's name, and it says and our name, and allows you and us, and look, take our form, if you work with another title company, we'll send you the Word document. Take out our name and put the other title company in there. It'll just allow the process to go a lot smoother.
Yeah.
So I would say when you go get that initial contract signed, part of your packet needs to be that borrower's authorization form. Sign that in the same day. Get it all signed.
Everybody's looking to close faster. It's always right. If it's 10 days, they want it to be in 5. So just take the one middleman out of it and just go ahead and do it.
It's always our fault, but y'all can help us out a little bit.
Yeah.
I mean, we're going to do our job, but it does help substantially.
Yeah. We know a lot about these properties before, you know, or very quickly, but then for some reason it's just like we can't get the rest. Okay. All right, so knowing generally what info title will need, that kind of goes to the intakes. We do need to know, we get contracts often, let's say if it's seller finance, or even if it's not, if it's a wholesale. is a single or double. Let us know as soon as you think you know. If you want to do it through a bond for deed or a credit sale, right? Let us know those things as quickly as you can up front. Sometimes that changes during the course of the closing process. That's no big deal, right? But it's at least starting somewhere. It gives us, in some instances, a better advantage than having just a question mark there of how should we proceed in this instance. And then giving your clients, anyone you're working with, a heads up that, hey, this is who we are and this will be in touch, right? And it is imperative part of the process to do it and cooperate and work with us timely so that, and that goes for any type of company, so that it doesn't get delayed.
Connecting send an email with them also helps. I mean,
Yeah.
if you soft hand or warm handoff in an email, say this is the title company, they're in touch with you, that is hugely helpful for us to do that.
Oh, that's funny. I didn't realize that. Courtney, you're still here. All right. Yeah, but all party information. You'd be so surprised how difficult it is sometimes to get an email or a phone number for a seller, right, or a seller's agent from a buyer or buyer's agent. And that, again, I mean, it just will slow the process because we want to, push the button as soon as possible on getting the ball rolling. And so does everyone, because we all know there's a contract, time is of the essence. So as much communicative information and or contact information you can give us is huge. Deposits and damages, Jared touched on this, right? Make the deposit substantial, particularly if you're calling it an EMD. It might be a little different in wholesaling, right? Your deposit to the seller might not be substantial, right? But to protect yourselves under your second contracts, obviously you want to make sure that you put some teeth into that. Like Jared said, damage provisions. Assigning, you can have, again, you can fully indemnify yourself maybe in your assignment contract. Says, yeah, I'm still obligated to perform under the AB contract, but if you back out, you're indemnifying me, right, and will hold me harmless for any and all claims that might arise with respect to my breach of the AB contract. So, it might be more difficult to negotiate that one, but it can still be done. All right, and then, yeah, due diligence periods. Make them long. Give yourself some room to back out. Oh, yeah, all right, so some just quick, so I know we're probably running out of time. All right, good. All right, legal descriptions, new survey info. If you know the survey's been done or if you happen to have the legal description, that's great. Don't use as per title if you can avoid it, only because if it's one of maybe multiple assessments and you just put the assessment number, but the assessment has multiple lots in it, or just if a partition's been done recently for some reason, right? This might not apply quite as much on wholesaling, but it still certainly could, and it's still a caveat. You can go on the assessor's website to pull a brief legal. Now, granted that you run into the same issue if there's a lot of lots assessed under one parcel number, but
today I was looking at a pre-screen for somebody, and they gave me the address, no other context in the context. Searched the address, property came up with the person's name, but they didn't tell me that there was 6 parcels that were all adjacent to each other, all totally separate that this person owned, and they intended to buy all 6. They just said, here's the address, this is the owner's name.
there you go.
If I do an assessment search to try to get a head start on it, I'm going to pull up the first lot that the assessor has on their run sheet, and the assessor's not going to let me know that there's 5 other properties that are adjacent to each other that may or may not be purchased. So again, as much context as you can.
Yeah, any additional information as per title. However, this is 25 acres in like anything would give you a better idea of like.
And look, if it's wrong, or if we still need to clarify it, that's okay. We'll clarify it. But it's better to start with at least more information to try to derive what the accurate information actually is than an ambiguous term, right? Like as per title. Again, that's not anyone's fault other than the fact that the clerk and the assessor might not communicate all that well, right? Seller finance provision stuff. So again, if you're doing a seller finance transaction, let us know to the best that you can on the front end what type of transaction that's going to look like. Your main ones are going to be your bond for deed and your credit sale. Utilizing the word shall and must versus may and can. If you want to create an obligation of the other party in your contract, right? If you want to create an obligation of the seller who's selling to you, you want to use Must and shall, not may and can. All right? I'd even say take will out. Take WIL out, put shall or must. Very pedantic lawyer stuff there, but it actually can really help
There's
out.
a huge difference.
Yeah. Use short sentences out of direct. I love this instruction. Jared, I think you put this together. The buyer must, right? The seller may, the parties agree that. You know, I was reading something today where it was just like, what did it say? It was like for 180 days, seller will keep the electricity in his name, but when the bill rolls over, then the buyer will be responsible, and then also, though, not responsible until the inspection of the sewer or the pump system. And I'm just like, hey, I wrote it as best I could. Just send it to them and tell us what they say, because like this happened soon and this doesn't make sense. I'm sure they'll bring it up. All right, bond for deed versus credit sale. Real quick, what's the difference? We talked about it earlier with the bond for deed. You're not getting title to the bond for deed until you fully perform, right? A bond for deed is technically a purchase agreement. It has got more bells and whistles in it, but that is what it is. And then a credit sale is me, if I'm buying from Kyle, he credit sales and conveys ownership to me at the day of closing, and he becomes a secured creditor, just like a bank would be, and I have to pay him. If I don't, he can foreclose on me. All right, a big difference in the two is, again, with the credit sale, his rights and recourse are foreclosure, right, which is to file a lawsuit, get the property sold at sheriff's sale, and then he gets made whole on what's owed to him. On a bond for deed, if I default, the law requires at least a 45-day notice to the seller or to the buyer. Hey, you're in default. This is what you need to do to cure it. If you don't cure it, I can cancel it unilaterally, and you can do so, and you remain the owner. Okay.
Is that clear to everybody?
It's also, when does the title transfer in those two?
So on a bond for deed, not until you pay me the last dollar you owe me, and otherwise you haven't breached anything, right? Then you're entitled to the deed, and I can be compelled by law to make sure I give it to you, right?
And John's family can too if you delay.
Yeah, because we've run into that where they said no, and we said, well, okay, sorry, just
terrible.
No, because people. So when a bond for deed, whenever on a refinance, the law, like a lender is allowed to do a refinance on a bond for deed, even though that buyer technically doesn't have ownership. We will.
Would it be treated as a purchase?
No, be treated as a refi. It's just treated as a refinance. What did you say?
They'll treat it as a refi if it's 12 months.
Yeah.
And it depends on the lender on the seasoning. Yeah, too. Yeah.
And then we do on the same day we have the seller come transfer their ownership over. On that refinance, that seller is a payoff as seen like a creditor. Yeah. They get paid out of the refinance. Now if it's primary residence, there's that 3-day rescission period. We got to have conversation with the seller, like you're gonna get your payoff after the 3 days. But it usually typically structured as a refinance from a lender standpoint.
Now, on a credit sale, the deed passes, ownership passes the day of closing, right? Yeah. So
I actually had this conversation today. A lot of people refer to as the credit sale as the subject to transaction, right? They'll say, well, if I'm doing a sub 2, that's a sale subject to the existing mortgage, and they don't see a bond for deed that's subject to the existing mortgage as a sub 2 deal. The way I look at it, and then John can correct me if I'm wrong, I look at it as you can do a bond for deed, which is like John said, is a contract to sell when the final price is paid, the buyer gets ownership, or a credit sale, in which case the buyer takes ownership immediately. In either one of those scenarios, it could be a free and clear transfer from the seller to the buyer, right? But also both of those scenarios, you can do a subject to deal to where a credit sale can be sold subject to the existing mortgage. A bond for deed can be done subject to the existing mortgage. So when somebody calls and says a sub 2 to me, I'm asking still, do you want to structure that as a bond for deed or a credit sale? If somebody says I want to do a credit sale, then I might ask them, is there an existing mortgage in place? Because you might do a credit sale subject to. They say it's a bond for deed, and I'll say, well, is there an existing mortgage going to stay in place? Because you can do a bond for deed subject to the existing mortgage.
I mean, any conveyance can be subject to technically, right? I mean, if he wants to quit claiming property that he's got a mortgage on, I'm accepting it's subject to. Every deed you're going to get is going to say subject to what's in the record, right? So I mean, that's going to be in any deed, even if you're just buying it with a regular mortgage or cash, right? So. That is important. I mean, we've kind of figured out, most of the time when that terminology subject to is referenced, and we do confirm, but we pretty much understand or already know that it's going to be a credit sale subject to. But that is an important caveat because it will help our staff.
If you're a real estate investor and you want to use a contract that is complete and has all the details in it. You can go to the LREC's website and download their mandatory contract. In that contract, when the financing provision is, there's an option for owner financing. You check that box, you fill out all the financing like you normally do, the interest rate, the term of the loan, how much is the percentage that's either put down or how much you're financing. And then in the other terms and conditions section, that's where you'll write, this is going to be structured as a bond for deed subject to this mortgage. There is a balloon payment of this many months. The escrow servicing company is Arena Escrow, because we do that servicing now. If we haven't talked
Yeah,
about it.
I'm about to, yeah.
All of those things you will put in the other terms and conditions, but otherwise you can use that financing provision of that contract to write pretty much everything except for what type of financing, if there's a balloon, and who's going to service the loan, who's going to pay the fees.
And a bond financing under the
It's not a bond
LREC
for
is
deed.
not a bond for deed. It's not a bond for deed. Totally different. Totally understand why
Good
that
question.
would seem like that.
So in the case of a bond for deed, whichever way it's going, does the seller still has more authority and
Yep.
it's
Yep.
better for the seller?
Yeah,
Yep.
If you're
inherently.
if you're the B, if you're the
Yep.
one buying it or gonna, it's better to do the credit sale and you have more.
Yep.
Yeah, the
Yeah.
only
Yep.
the only time I've seen a seller want to do a credit sale, not a bond for deed, they had a lot of real estate, and if you're, generally speaking, if you're going to do a bond for deed, the insurance company. Is there anybody in insurance in here? No. The insurance company is going to want the owner of that property to be the primary insured. So because this bond for deed, the title is transfer, that bond for deed seller stays as the primary insured. And if you make a claim as the primary, if there's a claim made on that property and the primary insured is the insured, then all their other insurance policy could be affected by making a claim on one property. And they had a lot of real estate, so they said, well, I don't want to be the primary insured. So credit sale, putting the property in the buyer's name and naming that seller as an additional insured, that primary insured making the claim would not necessarily affect their policies. So it was the only time that I saw a seller saying, I don't want to be on title anymore. I want the credit sale option. I don't want to potentially screw up my insurance on all my other properties.
Yeah, it's a good point.
So along that same line of thought, I mean, as a seller on bond for deed, liability associated with property has to be pond on it, there's a fence around it, somebody goes in and falls.
You can imagine that if somebody sues, they're going to sue all the people they can
Oh,
potentially
yeah.
sue. But if a bank's involved, like if I own my house, the bank's probably not going to get sued on on my primary residence, somebody gets hurt, right? They're not like the bank. They're usually not looped into those types of lawsuits. But as a seller on a bond for deed, if I'm a good lawyer and they're doing title, I'm going to sue the owner, the person who had possession of it, which is the bond for deed buyer, and I'm going to loop everybody in. Now, there's indemnity provisions and things that protect you as the bond for deed seller that might get you off the hook, but we all know that
You're still in a legal,
litigious-
you're still in a lawsuit at that
battle,
point,
you gotta
right there.
get you out.
Right.
So, there's inherent risk from a selling standpoint that insurance, liability potentially, and maybe not even liability, but the cost of litigation if you do get sued, all of that plays a factor.
So,
Taking that to the next step, are there any advantages financing-wise for financing other properties? If you were to sell a property, bond for deed, or credit sale, would a lender look at that sale differently?
See, there's a seasoning period. How long until
So like if they
if it's
wanted to
not
buy another
subject to,
property,
yeah.
count against that? Or-
Well, do they have an existing mortgage?
How long until the lender
Because if
looks
so,
at
that's
a lease,
that's all they're
property,
caring
or-
about,
or
right?
something that the contract is paying the debt.
If it's
where
paid
they
free
kinda
and
write
clear
that off,
and they're
like 6
underwriting it, then it
months,
might not,
2
it'd be
years,
kind of moot because they're going to say, what's the
Yeah.
maintenance, of
6 months.
of
yeah.
this
I've heard
property?
it's about 6
So
months, too.
they'd probably be more concerned with the debt ratio.
But after 6 months to a year, depending on what the loan program is, they'll take the contractual obligation of that buyer who has been paying consistently to offset the debt that you have, and I don't think they take 100% of the debt off, but they'll take a large percentage of it off and take it out of your debt to income ratio.
Okay.
Nice. Now, it might, if you're the seller in that situation for income purposes, yeah. I mean, well, that's just all right.
It all goes in.
Yeah. All right, so escrow and insurance, talk to that. All right, so we do have a company, Arena Escrow, where we can, if this makes a seller feel better type thing, or really, frankly, from a total matter of convenience, where we can service the monthly payments under bond or any seller finance transaction or a private money lender transaction. Where we're a neutral third-party custodian, you pay us via online platform, and we send it the money where it's supposed to go. All right, so sometimes that makes sellers feel better about it, right? Because they know that there might be somebody there who's keeping an eye on making sure they're getting paid timely, so that the buyer's meeting their obligations under the contract that you discussed or executed. Trying to think what else on that, but sometimes 1031 exchange, we do that too. But I'm moving along. Here we go.
Mr. Bob, you do 1031 exchange qualified intermediary work?
No, usually I'm prohibited from being an intermediary for my clients because I'm a fiduciary of them, so.
Yep.
We can help you out with that.
Send us your clients, Bob. All right. Yeah. So look, and this is kind of, we're going to go through this real quick. I know we're running on low on fumes here. Yeah. But just some of the stuff you want to look, that we look for, all right, when it comes to our title search, and some of the stuff you're going to want to be apprised of and understand when as early as you can be when you're underwriting a deal. Is a person in bankruptcy? That can throw a big wrench into the situation. Okay. Judgments. Have they any forbearance, partial claims mortgages where they're taking a lump sum, putting it towards the back on the payoff? Successions. A lot of times, we have to have conversations with people that look. We know, surviving spouse, you're on title, but you can't sell it until this is done, right? Until the succession is done. And succession, y'all in Louisiana, is what you hear in probate in other states. Is the formal conveyance of property from a deceased individual to his or her heirs. Okay. Undisclosed co-owners, right? Again, going back to making sure you got everybody's signature on that piece of paper, knowing who actually owns it, right? There could be encroachment issues, obviously. There might be something in the record that reflects that, survey or otherwise. Road access, hey, you're about to buy something that you can't get road to. Good luck doing a burr or anything on that and trying to refinance it. You better get some sort of right-of-way, right, set up first before you get too deep into this. And then is there any sort of pending foreclosure activity going on? Is it somehow better set up as a short sale? That we have people assign short sales. It's a remarkable feat to do that, but it works sometimes. Most of the time it doesn't.
Pre-screen.
Yeah.
Call us. Let us pre-screen it so we can just catch all this on the front end. Save you a month of time.
That's it. It really, in truly a month easily. Inspection, this is kind of more maybe your traditional type of real estate transaction, but inspection issues, look, obviously you're going to want to go look at that thing, so that's that inspection period. Give yourself as much time as you need to, because with some of these properties, it is warranted. You might need all that time to get to the bottom of whatever's going on with that piece of property, okay? So it's not just like hey, easy way to pull the parachute, right? I mean, it is something that you've got some legitimate due diligence. It might be a little bit more burdensome than normal. Whether you're getting appraisals on it, cancellations versus breach of contract, that's going back to the default stuff, just making sure, right, that you've got yourself protected if you need to, prosecute any claims. Pre-closing etiquette, love that word, they're fancy. Well, title companies are going to let you know when and where to be, send you documents for review, make sure the deposit's all good. Hey, are we missing anything? Lease prorations. I'm sure a lot of us deal with, multi-unit, multifamily type of transactions where, if you're buying or selling, you want to make sure that the lease security deposit's transferred. You're getting what portion of the month that you should be getting, right? Different closing rooms. We talked about that, right? There are situations, even in the most normal closing, right? We have to split people up because it can get hairy. So that covers the whole spectrum of real estate transactions. So if that's needed, by all means, just let us know. That's something on the front end that if you anticipate that, or as the closing progresses or the process progresses, it seems like that might be needed. We can accommodate that, and you would want to make sure that's done. Don't give no title companies can accept or not supposed to accept a personal check for over $2,500. Okay, so it's going to need to be certified. It's going to be wired, cashier's check. All right, we know that. ACH, you typically want to kind of stay away from. There are some instances where there are platforms where they're secure and they're built for real estate, so they can't claw back. But typically ACH has a bigger clawback period. What's up, John?
Personal checks not being over $2,500, is that for deposits too, or is that just for the?
So That's a great question. We got a $5,000 personal check last week, and it said, look, for purposes of the contract and fulfilling the obligation of the contract, this is sufficient. We can tell people we do have the deposit, but we need to call a buyer, make sure they either wire us or bring us certified funds, right? That's an escrow federal regulatory thing, right? For us to make sure the money is good. Now look, there might be more wiggle room on a deposit depending on how close the closing is, right? In terms of making sure those funds, but for your performance as a buyer in a contract, delivering that is sufficient, right? But for the escrow purposes, we kind of just got to make sure it's a little bit different. Powers of attorney versus certificates of authority. If you're an individual buying or selling, so if you're going to buy it in your name personally, or if you're selling it and it's owned in your personal name, you're going to use a power of attorney if you need somebody else to do something for you, right? If you're an LLC or you're a corporation, right? A trust, well, no, trust you would dependent. No. All right. If you're a corporation or an LLC, it's a certificate of authority or resolution that you don't have to get it signed, notarized technically, right? You can just use that sheet of paper that said, hey, at this meeting, the board said we can do this, or these are all the managers or members of an LLC. They sign here saying that Jared can sign on behalf of the LLC, right? Typically send those e-signing, easy to do. Closing fees, obviously, you're going to want to ask about and get your numbers right. Let's see, closing, discussions at the closing table. Hey, what might rub someone the wrong way if we bring it up? It might be that, the buyer dated the seller's wife in high school and we can't bring that up, right? Whatever the case might be.
Or I think the point of me putting this in there is like, you got to read the room a little bit. Like, if you're talking, and if you're a real estate agent and you give the key statement while we're in the middle of our closing package, like,
please don't do that.
Get a clue. Like, we're in the middle of signing papers and you're like going to say, oh, by the way, hey guys, we all signed this piece of paper that is not relevant to what we're doing. Like, or anything you're bringing up, it's always good because the process is, if you haven't ever done a closing package, and everybody has, we're going to go over our paperwork and we're going to leave for like 10 to 15 minutes. And you're going to have plenty of time to small talk with your client. Try not to interrupt your title attorney while he's in the middle of getting through the paperwork, because they're trying to get through the details. And I can't tell you how many times I'll have an agent just like out of the blue throw a couple papers on the thing, be like, oh, hey, by the way, can you make a copy of this? And will you sign this and explain shit? I'm like, guys.
Well, and it's all right, I don't mean to cut you off, but he's right. There's always going to be downtime, right? So there's going to be 10 minutes just to make copies. You can talk about the keys. You can talk about the garage. But the 10 minutes of throwing the papers down is like a pick six, because you stopped what you're doing, and now we're like 30 minutes behind. So
and sometimes it's not even
bad closing.
Sometimes it's like a folder of everything about that property that this person's kept since they've owned it. It's 20 pages. They want to go through it all. It's just like, I mean, really, like we got stuff to do. Yeah. You know, this person needs to get paid. That person needs to get paid. Let's go. And that's a caveat. Sorry, that's a.
We love small talk, and people will be happy.
Yeah.
Right, it's nice that they're getting along, right?
Yeah.
But
we have beverages and everything in there. Have as much fun as you like. Yeah, there you go.
Thank you. Good.
Yeah. All right. We talked about pass-through funding. We talked about wholesaling. Contact info if you need us. Hey, there we are. Sorry, Kyle.
Thanks, That's all right.
Kyle's in the middle of us.
I was in the back.
Right
I got
there.
chopped out of that.
All right. That's it.
The next button, Kyle, pops up in the
Yeah.
That's right.
Any questions? Y'all been a wonderfully captive audience. Thank you so much. Thank you.
All right, y'all, come talk to us if you need a pre-screen. I know we started with that and we end with that. That's such an important thing. If we can catch those issues in the front end, even let you know this isn't worth pursuing, such a big deal, and we'll do it. So just come, get our emails. Yeah. Email John or I. Look, if you want a pre-screen, we'll set up a file for you, and that way we can look at these firsthand.
Also, too, if y'all got questions about Arena Escrow, we do a lot of stuff. It's a good company. If let's say you're doing a renovation project, a private money lender wants it held with a custodian, we can do the draws, right? Follow the Private Work Act, all that stuff. So it's pretty broad scope in terms of what we offer. We're happy to talk more about that. Thank you.
Thank you.